Hi, my name's Stuart Salwin, and I'm a criminal defense attorney here in Scottsdale, Arizona. And in this video, what I'd like to do is talk to you about the criminal process to explain what happens when you get a court case in Scottsdale City Court. Okay, so this video is going to discuss what happens if you've been charged with a crime by the Scottsdale Police or by the Scottsdale Prosecutor's Office, and you have either a summons or a traffic ticket and complaint that's telling you to appear in Scottsdale City Court. So I'll talk about that, the process from beginning to end, so you know what to expect at the different stages during this criminal proceeding. So first off, how do you know if you have a criminal case in Scottsdale City Court? Well, more likely than not, if you have a criminal citation, you'll receive a traffic ticket and complaint from the Scottsdale Police Department. And that ticket will look something like this. It'll have the list of the charges that you're facing as determined by the Scottsdale police officer that arrested you, and then near the bottom, you'll see the location of your next court hearing. So that would be Scottsdale City Court, and you'll see the address for the Scottsdale City Court as well as the date and time that you're supposed to appear at that court. This court hearing is going to be known as your arraignment, and an arraignment is the first court hearing in a misdemeanor criminal case. And what happens at an arraignment, if you're not represented by an attorney, is that you go in and the judge will read the charges against you and ask you if you plead guilty or not guilty. If you plead guilty, you can be sentenced right then and there by the judge. If you plead not guilty, then a new court date will be set, and that's known as a pretrial conference hearing. At the arraignment, the judge may also set release conditions for you, and this will govern the freedom that you have to do certain things while the case is pending, such as whether you can have any contact with the victim, whether you can possess a firearm, or whether you can leave the state of Arizona while your case is going on. Now, some people ask, okay, well, if I believe that I committed the crime and I believe I'm guilty, should I just plead guilty at the arraignment? Well, that's almost never going to be a good idea because, first of all, keep in mind, it's the state's burden to prove that you're guilty. So what you want to do is you want to know whether the state can actually prove the charges against you. So you have to look at the evidence. And that evidence, known as the disclosure, that's not going to be available at the arraignment. That's going to be provided later at the pretrial conference date and afterwards if additional supplemental disclosure is needed. Also, you're going to want to speak to an attorney about your case. An attorney is going to be able to look at the evidence, to look at the law that you're actually charged with having violated and see, well, can the state prove this? What do they have to do to prove this? Are there points of the case that are weaker so that perhaps we could negotiate a lower charge for you or even get a dismissal entirely? So for these and many other reasons, it almost always makes sense to plead not guilty at an arraignment. Now, sometimes instead of getting a traffic ticket and complaint, you might get what's called a summons. So you're usually going to get a summons if you were arrested for a crime, but you weren't charged for the crime on the date that you were arrested. And what happens in those cases is that the police officers might think that you've committed a crime, but they need to conduct a further investigation. If it's a DUI case, they might need to send out the blood work to get that process to see what the BAC is before you can be charged with a certain type of DUI. And so what'll happen is instead of issuing the traffic ticket and complaint on the same day that you're arrested, those charges will later get submitted to the Scottsdale prosecutor's office. And then a prosecutor, could be months down the road, will then look at the police report and decide whether any charges should be filed against you. And they might decide not to file any charges against you, or they might decide to file the same charges that the police submitted, or maybe different types of charges altogether. And so what will happen if the prosecutor does decide to issue charges, then you'll receive a summons, usually in the mail. And this summons is going to tell you the charge against you and going to tell you that you need to appear in Scottsdale City Court in front of a judge at a specific date and time for your arraignment, similar to a traffic ticket and complaint. Now, in some circumstances, and this doesn't happen very often, but it can in some more serious cases, you may have been booked in jail and you may have already had your arraignment if you had to go see a judge and then release conditions were set. Maybe a bond was set. So sometimes you can get your arraignment much sooner than in other cases if you were booked in jail. Now, if you hire a defense attorney to represent you prior to your arraignment, then usually you're not going to have to show up for that arraignment. For misdemeanor cases in Scottsdale, your presence can be waived, meaning that your attorney can appear on your behalf, deal with the arraignment for you, enter a plea of not guilty, and then get a pretrial conference set. So you don't actually have to appear, usually, if you hire an attorney for your arraignment. And this can be a big benefit, especially if you are out of state. You don't live in Arizona, but you have this summons or complaint telling you have to appear in Scottsdale City Court, but you're already well outside of the state. Then this can be a good way to resolve the arraignment and to deal with the court dates without you having to constantly come back to Arizona to deal with the court case itself. So now let's talk about what happens once you get that next court date called the pretrial conference. So the pretrial conference is generally going to be where you're going to get discovery or the initial disclosure from the prosecutor. So this is the state's evidence against you, and the initial disclosure will generally consist of the police report and maybe some basic documents which describe what the police officer's investigation revealed and why the police think that you committed a crime. Now, this disclosure is not necessarily going to be all the discovery or all the evidence that exists in your case. In fact, it's usually not. There might be other pieces of disclosure, such as body cameras that the police officers were wearing, 911 calls, photos, other types of audio or video evidence that the state must disclose to you, but only if you request it. It's not something that will necessarily be disclosed automatically at the first pretrial conference. Usually, that's something that you do need to request in a motion, and of course, if you have an attorney, the attorney is going to be able to know what documents might be out there and request all of those so that you can see the whole scope of the evidence that exists in the case. Now, in addition to getting that initial evidence at the first pretrial conference, the first pretrial conference is also going to be the opportunity for the prosecutor and either you or your attorney to discuss and try to negotiate the case. And typically, a plea offer will be extended during that first pretrial conference. And what the plea offer is, of course, that's going to depend on the nature of the case, any aggravating or mitigating factors, evidence in your defense that your attorney was able to find. Those will all go into formulating that plea offer. Now, after the first pretrial conference, another court hearing is set if the case doesn't resolve at the first pretrial conference. And the second court hearing is going to be called a case management conference. And the case management conference is usually set at about 30 days from the first pretrial conference. And it functions very similar to the pretrial conference, even though it has a different name. It's basically another opportunity to discuss the case with the prosecutor, if there's any additional evidence that needs to be provided, additional mitigating material that your attorney's received that he or she could use to try to negotiate the case with the prosecutor. That can be discussed during the pretrial conference, the case management conference. And if any more discovery needs to be completed, that can also be requested at the case management conference. And then, if the case doesn't resolve at this case management conference. Then about 30 days out, there will be another hearing, and that hearing is called a trial readiness conference. Now, as the name suggests, a trial readiness conference is a hearing where the prosecutor and the defense attorney get in front of the judge and they say whether the case is ready to go to trial or not. So this is not the trial itself. This is still a pretrial hearing. Because there aren't any witnesses or anything like that. It's just a status conference for the judge, the prosecutor, and the defense attorney to all get together, talk about where this case is at, and whether trial needs to be set on this case or whether it looks like the case is going to resolve. Sometimes the trial readiness conference will get continued once or twice if there are some outstanding issues that need to be resolved before the case is ready to go to trial. Maybe witnesses need to be interviewed, or maybe there's still some last-minute negotiations where your attorney's trying to work out a deal with the prosecutor. But if the case does go to trial, then what'll happen at one of the trial readiness conferences is the judge will set a date for trial, and the trial is going to be the time when either a judge or a jury, depending on the type of case that you have, will make the ultimate decision of guilty or not guilty in your case. Okay, so now that we've talked about the basic structure for a case in Scottsdale City Court, there's a few things that you should keep in mind about this process. And one of those is that at any of these hearings, there can be a time where you decide that you want to change your plea. Maybe you want to accept a plea agreement that you and your attorney view as favorable based on the facts of the case. So you don't have to go through all of these hearings that I just described in order to resolve your case necessarily. If you decide that you want to accept a plea offer, then a motion can be filed with the court to change any of these court dates to a change of plea hearing. And a change of plea hearing, as the name suggests, would be when you go in front of the judge, enter into a plea agreement, and then the judge will usually accept your plea at that point and then pronounce sentence on you, which is also usually negotiated in the plea agreement at that hearing. So that's the basic structure of the court process for a criminal case specifically in Scottsdale, Arizona. I hope you found this video helpful, and if you do have a case pending in Scottsdale City Court, a criminal case, and you have some more questions, you'd like to speak to an attorney about your case, then feel free to give my office a call. The phone number is going to be in the description below, and we offer free consultations on criminal defense matters. Thanks for watching.